So, you're making a personal injury claim in Scotland, and you're wondering what happens first. Well, there's a single document that officially gets the ball rolling. It's called the Intimation of Claim, and it's the moment your case goes from being just an idea to a formal, legal reality. So, what is it, and why does it matter so much? Let's break it down.
Look, chances are if you're watching this, you've had an accident and you've probably already spoken to a solicitor. You know you want to make a claim, but that first official step can feel like a bit of a mystery. What does it actually look like? Well, that's exactly what we're focused on today, that formal letter that kickstarts everything with the other side.
So, what is this thing really? At its core, the intimation of claim is a formal letter. Simple as that. Your solicitor sends it to the person or company you hold responsible. They're called the defender, and it officially tells them you are seeking compensation. This is the moment it all becomes real for them. They're formally on notice.
All right, so here's our game plan for this explainer. We're going to follow the journey of this crucial letter. First, we'll look inside the letter itself. Then, we'll see what it triggers in the insurer's playbook. We'll break down their all-important response, and finally, map out the path to resolution that opens up right after that.
Okay, let's dive right into Section 1, inside the letter. Now, you might think this is just a simple, hey, I'm making a claim letter, but it is so much more than that. It's actually a really strategic document, and it's designed to do 4 very specific jobs right from the get-go.
I mean, it's kind of wild how much heavy lifting this one letter does. First, it's a notification. Pretty obvious, right? They can't ever say they didn't know a claim was coming. Second, identification. It forces them to tell you who their insurer is so your solicitor knows who to talk to. Third, and this one, this is a biggie, preservation. It legally requires them to save key evidence. We're talking CCTV footage, accident reports, you name it, before it gets deleted. And finally, it's procedural. It officially starts the clock on the whole process.
Now, you should also note that there are kind of 2 flavors of this letter. You might send an early intimation right away. Think of it as an early warning shot, mostly to lock down that evidence. But the full letter of claim usually comes a bit later, once all your medical reports are in and your solicitor has calculated your losses. This is the letter that really opens negotiations on how much your claim is worth, although in simple cases, you can sometimes just combine them into one.
So if we were to open up that full letter of claim, what would we see? Well, think of it like the opening chapter of your case file. It lays out all the key facts, who's who, a detailed play-by-play of the accident, and the legal reasons why they're at fault. Then it gets into your injuries, backed up by a medical report, and lists out every single financial loss. And it all wraps up with one clear question: do you accept responsibility?
Okay, so your solicitor hits send. The letter's out there. What happens now? Well, this is where the spotlight moves to the other side of the stage. Let's pull back the curtain and take a look at the insurer's typical playbook once they get that letter.
You know, the second that letter lands on their desk, it kicks off a very specific, almost predictable chain of events. A file gets opened just for you. A claims handler gets assigned to your case. They immediately call their client, the defender, to get their side of the story. And then they start their own investigation, looking for their own evidence to build their own picture of what went down.
So they do all that digging, all that internal work, and it all funnels down to this one moment. This is the big pivot point for your entire claim, the official response that's going to determine everything that happens next.
Yep, after all of that, it really just comes down to one simple but massive question. After their investigation, is the insurer going to accept that their client was at fault? Their answer is going to set the entire tone, the strategy, and the timeline for your case from here on out.
Their response is going to fall into one of 3 camps. Best case scenario, an admission. Bam! Great news. They accept fault, and now the conversation just becomes about how much your claim is worth. Then you've got a denial. Okay, this means we've got a bit of a fight on our hands. We have to prove our case, and court becomes a real possibility. And finally, there's the middle ground, a partial admission, where they say, yeah, we were at fault, but so were you, which can affect your final compensation. Right, so whether they say yes, no, or kinda, their answer officially kicks off the next phase of this whole journey. This is the path from that initial letter all the way to a final resolution, whether that's a settlement or a court decision.
And wow, this slide really shows you the massive difference in timelines we're talking about here. A super straightforward car accident where everyone agrees what happened, that could be settled in a few months. But a really complex case like an industrial disease claim or something where the other side is fighting you tooth and nail, that could take years. The bottom line, you gotta be patient.
So you might be thinking, what can I do? Am I just sitting on the sidelines? Absolutely not. Your role here is huge. Be proactive. Keep your solicitor in the loop on your recovery.
Go to every single medical appointment, and I mean every single one. Keep a detailed diary of all your expenses, and when your solicitor asks for something, get back to them quickly. You are a crucial partner in your own case.
And I want to leave you with one final, super important piece of advice. This is a big one. If the insurer or their lawyers try to call you or email you directly, do not engage. Everything, and I mean everything, must go through your solicitor. They are your shield. They know the game, and they will protect your interests every step of the way. You know, when you really boil it all down, it comes back to this one idea. Just understanding what this first letter does, what it sets in motion, empowers you. It takes the mystery out of the process and gives you a solid, grounded picture of the journey ahead.
Look, that first letter, the intimation of claim, it's just step one, but it's a massive step. By understanding what it's really for and what comes after, you're no longer just a passenger in this process. So, let me ask you this. Knowing what this first step truly means, don't you feel more prepared for the road ahead?